Hi, I'm Matt O'Connor from the O'Connor Law Firm in Kansas City, Missouri, here to offer you a few tips on the do's and don'ts when you're pulled over for a suspected DUI or operating a motor vehicle under the influence of alcohol. First, at the outset, let me tell you, it's a lot cheaper to take a cab, even if your cab ride is across town and it's $50, because by the time you get done paying for a lawyer, the classes that you have to take, the inconvenience of losing your license for anywhere from 30 to 90 days, or if you don't blow a year, the cost of a cab starts looking like a pretty good comparison. So I can encourage everybody to do the same thing that I do, and that is if you have one drink or two drinks especially, take a cab. Really, if you're going to have one and plan ahead, take a cab there so you don't have to worry about your car the next day. So back to the tips. What do you do if you're pulled over? Well, first of all, you maintain your cool and have your license and registration handy. I wouldn't recommend fishing around in your glove box until the officer tells you to do so. So let's start from the beginning. The officer pulls you over. A lot of times they will have you step out of the car, and usually that's for officer safety. Realize everything you are doing is most likely on videotape. So now is not the time to be funny. Now is not the time to practice your stand-up comedy routine standing by the side of the road with the officer who wants to give you the field sobriety test. Now, what do you do if you know that you're over the legal limit? And it does not take much to be over the legal limit. Let's say you've had 5 drinks in a couple-hour period of time, you're likely going to be over the legal limit. So do you take the field sobriety test at all? Do you take the breath test? It depends on what county you are in. And I can't offer too specific of advice, but if you are in Platte County, here in the Kansas City metropolitan area, or Cass County, in the outlying counties, definitely want to make sure you go ahead and take the breath test, because if you don't take the breath test, there's a high probability that your license will be revoked for a year. If it is your first time and there is not an accident involved, you can keep your license in Jackson and Clay County, but there's some hoops you have to jump through, so it's not always a guaranteed. And again, that only applies to people who have never had an alcohol contact, which means being arrested for suspected drunk driving, or someone, if you have not been involved in an accident. If there's an accident, they will not offer you those two diversion type programs in Clay and Jackson County. So let's say you take the field sobriety test. You want to make sure that you listen to the officer's instructions very carefully and follow through. If you have any known physical ailments or deformities, make sure you state those clearly and inform them of that at the time. If you have astigmatism or other disorders of the eye that are going to affect the horizontal gaze nystagmus, that is where they hold their pen or their finger generally 12 to 15 inches from your nose, and then you track it. What they're looking for there is what's called a lack of smooth pursuit. The theory is that medically, if you are intoxicated, your eyes will tick, 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 tick back with the horizontal gaze nystagmus test, if the officer is giving you that in the proper way. But again, it's got to be 12 to 15 inches from your nose to be accurate. There's a lot of little details that have to be accurate in order for the field sobriety test to hold up in court. But generally, it is extremely difficult to get those results thrown out, because a lot of it is just based on officer observation. So you've got the heel to turn, you've got the horizontal gaze nystagmus. There is no ABC test. I have seen some officers who give that, but it is not on the standardized test, so it's a little bit odd if you ever get that. There's the walk and turn test as well. And again, remember, you're on video, so it's not the time to be funny. Concentrate on trying to perform the test as well as you can. When you get to the police station, now they may give you a portable breath test at the scene, which you do not have to take again, but again, that's a decision you should make after contacting a lawyer. But let's say you've not taken the portable breath test and you're at the police station and they're firing up the data master, which is the machine which will read your blood alcohol content. You have 20 minutes to contact a lawyer. And generally, people don't get pulled over for DUI 9 to 5, so it is extremely difficult to reach a lawyer, especially if you don't have one's cell phone number handy. So during that period of time, you should use that time to try to reach a lawyer. While you're considering and trying to reach a lawyer, also you should start factoring in how many drinks you had, and then whether or not stalling. And you really can't stall the test, but if you have that 20 minutes to try to reach an officer, you can try to do in your head your own retrograde analysis, and that is, was I drinking a lot more toward the end, so the longer I wait, the higher my blood alcohol content's going to be, or is it a situation that if you take the test immediately, is it going to be better? All those things should be running through your head at this point, as well as why in the world did I get behind the wheel when I was intoxicated. So let's say you blow over the legal limit. What's going to happen then? Well, they're going to give you a temporary driving privilege, and you have 15 days from the time that you receive that in order to request your administrative hearing. Now, what's an administrative hearing? That's when you and or your lawyer can go through the police reports and the information received from the packet that's received from the police department or the highway patrol that goes to the Department of Revenue. That's the point where your lawyer would make any notes as to things that were defective in the field sobriety test, making sure that the machine that was used for the breath test was calibrated, all of those things, very technical, very specific type issues. And you have a right to a hearing. Now, how that hearing works is you can either do it in person or you can do it over the telephone. And again, that's a decision you should make after consulting with your lawyer. But make sure you request that hearing, because if you don't within that time period, you can't request it later. There are some advantages to requesting the hearing, even though the chance of success on the administrative hearing is very slight. I would say 1 in 1,000 as a rough guesstimate. Most of the stops and the determinations are upheld by the Department of Revenue. You can appeal it later, and there's some options there as well. But at the beginning stage, you want to request the hearing, and here's why. You can then sort of budget your time ahead that you're going to be without your license, because that's the odds on what's going to happen. In Missouri, we have what's called the hard 30. So once you have the hearing for your driver's license, whether it should be suspended or not, your license will be suspended for 90 days, the first 30 of which you cannot drive at all. And it is a crime to drive during that 30 days. So driving while suspended is going to get you in more trouble, so you really can't drive during that period of time. After that 30 days, you can then have what's called a limited driving privilege for another 60 days. So the total is 90. In the last 60 of it, you can drive to and from work, doctor's appointments, things of that nature, as long as it's delineated in the temporary or your driving privilege that last 60 days. So what's likely to happen in court? Well, any trained monkey lawyer can likely get you what's called a suspended imposition of sentence. And they're going to tell you, don't worry about it, it's not going to show up on your record. Well, the arrest is always going to show up on your record. It's nearly impossible to get those expunged in Missouri. There are some procedures, but very unlikely. So the plea to a DUI, while not a conviction, if you get the suspended imposition of sentence, you'll be on probation for 2 years. You'll have to probably do some community service. You'll have to go to the Mothers Against Drunk Drivers Victim Impact Panel. And you'll have to complete a program called SATOP, which is a Substance Abuse Traffic Offenders Program. It's quite pricey. It's 2 phases. There's the initial phase where they do the evaluation, and they determine what treatment is should be implemented for you. Most of the time, it's just another class and things of that nature, unless your blood alcohol level was really high, or there's some extenuating circumstances that they believe warrant a more serious treatment alternative, up to and including inpatient treatment. But that is often not used, so I wouldn't sweat that one at the outset. So you go to court, your lawyer works out a resolution with the prosecutor. You're on probation most likely. You're going to have to pay some fines. And the way that works is, if you notice, when you get a DUI, you're going to get 2 tickets. You're going to get the ticket for operating a motor vehicle while under the influence of alcohol, and another ticket for failure to maintain a lane or speeding, whatever the initial reason was that the officer pulled you over. Why they do that is because they stick you with a higher fine on the what they call companion ticket, the speeding, the failure to maintain a lane, things of that nature. That way they can assess a fine that generates some revenue for the court, whereas on the suspended imposition of sentence on probation for the DUI, they don't get anything for that except the court costs. So that's why there's 2 tickets, if you've ever wondered. One thing I want to also talk about is everybody has this misconception that there's a big difference between DWI, DUI, etc., etc. Well, actually, neither are correct. If you look at the statutes in Missouri, And you can go to their website for the Department of Revenue Driver's License Bureau, and they have them all listed out there. It's operating a motor vehicle that renders you incapable of safely doing so, is kind of paraphrasing what the statute says. It has nothing about DUI or DWI. So don't bother with that debate, because really neither matters. It's operating the motor vehicle in an impaired condition, and it's the key language there. So I hope this answered all of your questions. One thing I do want to point out before I conclude this, though, is if you refuse to take the test, then you go to court, but you have to file that petition within the court within 30 days. So make sure that if you refused to take the breath test, that you have retained a lawyer or yourself have petitioned the court to review that refusal, because if you don't, you lose your license for 1 year. And again, it's not just part of the year, it's the entire year. And if you drive while that license is suspended, it's another crime called driving while suspended. So you want to or driving while revoked. You want to make sure that you are not driving under those circumstances, and you also want to make sure that you get your hearing request in a timely manner. So again, reminding you, the best advice I can give you is take a cab, have a designated driver, save yourself a lot of expense, and risking others on the highway, that's the best way to do it. I would prefer not to have any DUI clients. It would be nice, but in reality, I guess that's just not the way the world works. And this has been Matt O'Connor from the O'Connor Law Firm with tips on what to do when you're pulled over for DUI and the implications thereof.